or need time off work for family, or health things, if you don't provide that information, you can lose a lot of money as a result of that. And when we get to the Family Medical Leave Act and California Family Rights Act, I'm going to go into that a little bit more. Employers who have failed to provide employees with information about their rights to take time off of work has cost them millions of dollars. And so while it's not a very glamorous topic, it is a very important topic. So glad you're here. We don't have a fancy PowerPoint today, just have this handout for you. And it is filled with information on what you have to provide employees and what maybe you should consider providing employees. So what you have to provide is in bold, and then some other things to consider is not bolded. And I'm going to go through here and not just tell you about, okay, this is the information you have to give, but some other information surrounding it that you might not be aware of, where it gets into the legal responsibilities of employers and best practices as well. So jump in anytime. Let me know if you have any questions or concerns, and we'll just go from there. So first of all, you know you have to have that big old poster up on the wall that has all of the information about employees' rights. And so you're probably aware of that poster, but here's all the stuff that it has to have on it. And sorry, I'm moving out of the camera range. Okay, so you need to have the Employee Polygraph Protection Act information on it that tells employees that you will not polygraph them. It is against the law in California to make employees or applicants take lie detector tests. Employees' rights under the NLRA. Well, that one has been postponed a little bit, and so that's one of the things that people are frequently asking. Do we have to have the poster up that tells employees about their right to unionize? And it has been postponed for a little while longer yet, so not have to have that one up yet. Equal Employment Opportunity is the law, so the EEOC, you've got to have that. Family Medical Leave Act, so FMLA, you got to have that. Federal minimum wage, so even though California's minimum wage is higher than the federal, we have to post the federal minimum wage as well. And your rights under USERRA. And that allows service members to know what their rights are. So that's just the federal stuff. Now here's the state stuff. California Family Rights Act, pregnancy disability leave, got to have that stuff up. California's minimum wage. So you have to have the federal minimum wage and California minimum wage, even though California's is higher. And so you have to have your wage orders up, which I'll talk about that in just a little bit more. Discrimination and harassment are prevented or prohibited. You have to have that. Emergency phone numbers. Notice to employees about what to do if they get hurt at work. Notice to employees about unemployment insurance, disability insurance, payday notice, pregnancy disability leave, safety and health protection, time off for voting, whistleblower protection. So all of that has to be on your poster. And the easiest way to get that information on your poster is just order it from the California Chamber of Commerce. They've got all that information on there. So that's why under required posters, I'm telling you, just purchase the employer poster. It has all that information, except it does not have your wage orders on that. Now, most employers are unfamiliar about what their wage orders are and what a posting about it is supposed to look like. Every industry or occupation in California is put into a specific wage order. And the wage order will tell you what the requirements are for employers in that specific occupation or industry. There are 13 of them. And so they're usually the same for all industries, but not always. For example, in the oil fields, things are a little bit different than they are in ag, which are a little bit different than they are in healthcare, which are a little bit different than they are in businesses like this. And so the wage order says these are the rules and requirements according to your industry or occupation. Employers have to post that next to their posters so that their employees can see. And this is a violation I see all over the place. When I go out to check on employers, do you have the required postings up? Do you have the required pamphlets? All of that. This is the violation I see more often than not, is employers don't even know that there is a wage order. They have no idea about what wage order they fall under. And when employers call us and ask us, well, can I do this? Can I do that? The first thing we do is we check the wage order. What does your wage order say? So it's that important, but for the most part, employers are oblivious to it. So that's one of the things to not be oblivious to. Yes.
If an employer falls into more than one wage order, are they required to post both? Or?
Yes.
Okay.
Yeah. And what this is all about is telling employees of their rights. And so that's what those wage orders are. Now, employees are oblivious to what they are, but still, you've got to let all applicable employees know what their rights are. So that's the point of that. Oh, and by the way, that poster is supposed to be posted where applicants can see it, not just employees. And so really, it should be out in people's lobbies. Yeah, so for the most part, it's not. Most employers don't put it out in their lobbies, but that's where it's supposed to be. It's letting applicants and employees know of their rights. So is the poster police going to come by and cite you? Probably not, but just for your information, that's where it's supposed to be. All right, so a little bit more under required posters. There's the Beck poster for federal contractors. So if anybody's doing business with the federal government, there's different rules that apply for the federal government. And so you want to post that poster as well. And the unemployment disability insurance, that is part of the Cal Chamber poster. So if you're going to order that, it's already on there. But if you're not, it's got to be a separate posting. So that's the first thing. You've got to post all this information to tell employees what their rights are. Now, do employees read it? No, for the most part they don't, but it's still got to be there. Okay, so any questions or concerns about posters? All right, moving on. So before the employment relationship, one of the things that I think some people don't know about is the fact that you are not required to have applications. It is not a requirement by law that employers have applications. But if you are going to have an application, you've got to follow some rules with the application. So one of the things that you need to make sure about applications is that they're not asking inappropriate information. What would be considered to be inappropriate information, do you think? Age. Religion. Sorry? Medical information. What's that?
Status.
Marital status. Good. And also, one of the things, it's not that you're not allowed to ask it, but it's the best practice not to on the application, is Social Security number. And so this is one of the things when I'm reviewing applications, I still see people having Social Security numbers on their application. And so the reason that we suggest don't have them is because you don't want a lot of Social Security numbers floating around on somebody's desk somewhere. And it's not necessary until you hire somebody. So you're going to have applications of people you do not hire. You don't need their Social Security number until you actually hire them. So don't put yourself in a position where somebody could use that, get those Social Security numbers and then commit identity theft or something like that with it. Because if that happens, the employer more than likely is going to be liable for it. All right, so I say be careful about notations on applications. And so again, if you're going to have applications, be careful of the notations that you put on them, because if you do not hire someone, that application is something that you want to be able to have on hand to protect yourself from a discrimination complaint or lawsuit. And so even if you are not hiring somebody, keep the applications on file for about 3 years. And so be careful about the notations you put on there, because that can be used as evidence against you if you do not hire somebody. And here's the best scenario that I have for that. This actually happened. A jewelry owner, guy owned a jewelry store, and he was hiring someone. He did not hire a particular person. This person he did not hire because he put on the application, well, what he put on was no Jew, but what he meant was no jewelry experience. And so the person he did not hire, of course, was Jewish, and of course filed a discrimination claim, and of course that application said no Jew, and of course the employer lost. So that's why on applications, be very careful about abbreviations and that kind of stuff. It can come back to bite you. And as I said, keep applications on file for 3 years of people you do not hire. And the reason we say 3 years is that statute of limitations for a discrimination complaint is typically 1 year, but extenuating circumstances kind of draw them out sometimes. And so 3 years is just being safe. And one of the things, you are not required to keep unsolicited resumes or applications. So I know that there are some companies who say, we will not accept applications unless we're hiring. And if somebody goes in and sends it in, you can just throw it away. You don't have to keep it as long as you don't look at it, okay? But the key is not looking at it and reviewing it. And so that's one of the things that some companies do to protect themselves even further, is we're not even accepting applications when we're not hiring. All right, any questions about applications? Moving on. So EEO data. So if you are a large company like the Bakersfield Californian, and what company are you from? Okay, very good. How large is your organization? Okay, so you're still under that 50 yucky threshold. Okay, so this does not apply to you, but it does apply to Shannon. When you have at least 100 employees, the federal government requires you on an annual basis to let them know the demographics of your workforce. You have to tell them what sex they are, what race they are, and what their occupation is. Now, this is contradictory to what the federal government tells us, is that we're not supposed to care about what sex people are, what race people are. We're not supposed to ask them what sex they are or what race they are. And yet the federal government now wants us to tell them what sex they are and what race they are. How do we do that? So one of the things that you can do is you can have a voluntary information sheet where you pass it out to your employees and say, please complete this, and this is how we'll collect our data. If they refuse to, or if you don't want to do that, you can walk around and go, you look like a white woman, and you look like a white woman, and you look like a white guy, and you can record it that way. And so they allow you to visually collect the data if you want to. So that's kind of one of those don't do it until we tell you to do it kind of thing. Now, one of the things that you can do is you can collect data on your applicants also. And we had a client who would have people complete this voluntary information sheet and then attach it to the application. And then once they hired somebody, they would detach it from the application and put it in their EEO file. And we said, do not do that anymore. Any ideas why? Because if it's with the application, it lets the person know what sex they are, what race they are, et cetera. And they might make employment decisions based upon that information. And so if you're going to collect that data, it has to be separate from the applications. And so advice for the most part is that unless you have to collect it, don't. But if you're a large company, then you have to collect it after you hire people. So that's how that works. Job descriptions are not required by law. But if you're going to have them, one of the things you want to make sure you do is list the essential job duties. And the reason for that is because you have to be able to demonstrate whether somebody can perform their essential job duties or not, with a reasonable accommodation or not. And if they cannot perform their essential job duties, you do not have to retain them. And so that's one of the things, if you are not familiar with how to identify essential job duties and create job descriptions and that kind of thing, then there is help available for you. As well as the next thing, exempt and non-exempt analysis. You are not required to do any kind of analysis or put it on paper as whether people are exempt or non-exempt. You do have to classify them properly. Failure to classify someone properly can cost you lots of money. And this is where employers are really getting hammered in California, is classifying employees as exempt. You're salaried, I don't have to pay you overtime, I don't have to worry about those pesky lunch breaks and rest periods. So you're an exempt employee. And most employees are not exempt employees. Most of them are non-exempt. And so you have to pay them overtime. You have to give them meal periods. Yes, sir?
Is there a standard form to do this questionnaire?
There is, that the Cal Chamber has. One of the things is that I do these also, and goes through and lists what exempt duties are and how often they perform exempt duties, what the non-exempt duties are and how often they perform non-exempt duties. And in California, it's not just a matter of performing exempt duties, you have to do it most of the time. So at least 51% of the employee's time has to be spent performing exempt duties in order to be exempt. And so there is a form that you can use. I also have a template that I use that I developed, and it's worked very nicely, and I do it for lots of clients of ours, and telling them based upon the job description, and this is why job descriptions are important, based upon the job description, the list of the duties, it appears that most of them are exempt, so therefore the position probably is exempt, or on the other side, which is more often than not, it appears that it's non-exempt. And so employers can keep that on file in case they're ever challenged. All right, interview questions. You're not required to interview anybody. But if you do, you've got to make sure that your questions are legal. And so what would be questions that are not legal? And we kind of talked about that before: marital status, age, religion, what disabilities you have, what kind of medications you're on, health information, all of that kind of stuff. So one of the things, if you are uncertain about what interview questions you can ask, you can go on the DFEH website, Department of Fair Employment and Housing website, and it has a nice little form that tells you you can ask this, but you can't ask that. So that's really helpful. All right, testing. So one of the things employers are doing more and more is providing tests for employees before they actually hire them to make sure that they're actually qualified to do the job. Testing is fine, but you've got to be careful because you've got to test everybody. You've got to demonstrate that the tests are applicable to the job, and you've got to make sure that they don't inadvertently favor one race over another race and that kind of thing. So employers do get in trouble for doing testing of applicants when they only test some but not everybody, when the test doesn't even apply to the job, that kind of thing. So got to be careful with your testing.
I have a question on that.
Yes.
Is it illegal to test somebody if you're looking for a bilingual employee?
Mm-hmm.
Is it illegal to test them on Spanish grammar, for example?
No, that's a great idea. If somebody is required to be bilingual, which by the way, employers can require employees to be bilingual, that's not discrimination, then yes, that you would certainly want to have a certified translator engage in a conversation with them to make sure that they actually can speak the language. You betcha. All right, so page 2, background check waivers. So if you're going to do a criminal background check, any kind of credit check, talking to previous employers, whatever, you have to get the applicant's permission to be able to do that. And one of the things is that I've had employers who don't do any kind of background checking whatsoever. Usually a lot of folks in the restaurant industry, you know, we just hire, and if they don't work out, we fire them and that kind of thing. Well, the problem with that is that if you do no kind of background check whatsoever, and you hire somebody who becomes violent on the job, and if you would have called their previous employer, you would have found out they were violent on that job too. And so now that violence on your job, are you liable for it? You bet. That's something called negligent hiring. And so if you do no kind of background check whatsoever, and you hire somebody who, if you would have just made a phone call, you could have found something out about, then negligent hiring could be a lawsuit you face. Yes, sir.
Just going back to that, if there's a question on application that says, are you a felon? Is that a legal question?
Yeah, well, the question is, have you had any criminal convictions? And so yes, that is a legal question to ask on an application, you bet. Now, just because somebody has had a felony doesn't mean you can automatically discriminate against them. And the EEOC is really going after employers for doing that, for having policies that say we hire no felons, or their practices, they hire no felons, or anyone with a criminal background. And so the thing is that according to them, people of color have criminal backgrounds more than Caucasians. And so if you're automatically saying we're not hiring felons, you're automatically discriminating against people of color, which of course is against the law. And so that's why employers are getting sued all over the place for having these general policies, we will not hire anyone with a criminal background.
Going back to what you said before, the hiring a violent person, if you would have done your background checks and stuff, you can call the previous employer. Isn't it illegal for the previous employer to discuss that?
No. One of the things, the misconceptions that people have is that you cannot answer any questions unless you're going to get sued for defamation. And so we have a labor code that protects employers that says that you can provide what their position was, what their dates of hire were, and termination date, and then whether they're rehirable or not rehirable. So this labor code specifically protects employers to give that information. But even more so, if you have documentation and you have evidence and that kind of thing that somebody did things at your place of employment, and you want to tell the person who's on the phone, no, they never showed up for work, or they never showed up on time, and I've got the documentation, I've got the time cards, they set fire to the building once, here's the fire department's report, you know, that kind of stuff. You can pass that stuff along and they can't get you for defamation. So there's a whole bunch of employers who are afraid of defamation lawsuits for really no reason whatsoever. If you are providing information in good faith and you've done investigations and you have documentation and all of that kind of stuff, then you're going to be safe. Yeah. Yes, sir.
What about an employer, a previous employer, calling the new employer without being asked?
Without being
Yes, say that you're interviewing a job and the employer doesn't go and ask for that information, and your previous employer calls, like we were interviewing at, and says this is what he's done.
well, it would be the same kind of rules. I don't know.
It wasn't solicited from the previous employer.
Yeah, it doesn't have to be solicited. Yeah. And so that's a good point, is that the protection isn't there just whether it's solicited or not. Yeah.
Okay.
All right, very good. So during the employment relationship, here's some stuff that you have to do, especially right when the person is hired. So a new hire checklist is not a requirement. It's a great idea, though, to have a listing of all of the things that you have to provide the employee, and just checking off the list that you've done it, put in their personnel file. So that's good stuff, especially when you're having the employee sign that they have received the information. So that protects you. You're not required to provide an employment offer letter to anyone, but especially for high level people, it's a good idea to do so. Letting them know what the title is, whether they're exempt or non-exempt, how much money they're going to be making, work schedule, et cetera, et cetera. And one of the things that I've seen employers do is provide that offer letter and say, these are the terms of your employment based upon you passing pre-employment physical, drug test, what have you. And then when they do that, then sending, okay, you passed it, so we're good to go. This is your start date. This is who you report to. This is where you start, etc. So it's not a requirement to do it, but it's a good practice. And I have a friend who was just offered a job by a big employer. And she said, well, can I have the conditions of employment in writing? And they said, no, we don't do that. And she decided to turn down the offer in part because she thought, my gosh, you're not even going to put it in writing what the terms of my condition are. We're doing all of this verbally. She felt very uncomfortable with that and so passed. And so that's one of the reasons to have those things, especially with higher level folks, is that it just looks very professional, it looks more locked in. For those people who need stuff in writing, you've got it. All right, so what do you have to provide? You know this stuff. You've got to give them a W form to fill out and then have on file an I-9. And so everyone's familiar with that, I would think. If you're employing someone who's under the age of 18, you have to have a work permit on file at your place of employment and at the district, the school district. And a lot of people think if they're working during the summertime, they are not required to have a work permit. That is not true. They've got to have it during the summertime too. There are only certain jobs that minors can do. You can't have them driving and delivering stuff around. You can't have them working in hazardous occupations. So just a whole bunch of stuff. So if that's something that you do at all, then you really need to be familiar with all of that stuff. Yes, sir.
Would that be through a temp service as well? So say like if somebody hires a temp service, would the temp service do that?
Yes.
Instead of the employer
Mm-hmm. Yeah. All right.
17-year-olds.
Well, and that's one of the things. It's perfectly legal to say we don't hire anyone under the age of 18. So you can do that. Sexual harassment information sheet. So even if you have an employee handbook that has a sexual harassment policy in it and you give that to the new employee, you have to provide them with a separate information sheet that says sexual harassment is forbidden by law. So the DFEH has that. You can print it off their website and hand it out to them. So that's very easy to do, but that's very important. And that's one of the things on your employee checklist, you want to have that on there so that if you get sued for harassment, you can say, look, we provided all the information in order to prohibit harassment from happening. Yeah.
That pamphlet enough or a training is necessary?
It's not required to provide the training, but it's a great idea. Yeah. The training requirement is only for larger employers, 50 or more, so not you yet, but for their supervisors. So that's the only harassment training requirement at this point. But it's a good idea. But what a lot of employers do is they plop the new employee down through their orientation process, and they have them watch a tape that's 20 years old. And one of the things, the whole onboarding process, you know, when you're doing this stuff, you've got to add some other things to the onboarding process besides here's your form, fill this out, watch this old stupid video, do that kind of stuff. You've got to do some other things to to make the employee feel really connected to the organization, and that's called onboarding. Because the thing is that if you don't provide extra stuff to the employee, a lot of times they don't feel connected to the organization. They're around for a couple of days, nobody said hi to them, the boss doesn't even know they're there, their office isn't ready yet, they're in a storage unit someplace, they've got no computer, nobody knows what's happening, their supervisor's on vacation, they're not being trained yet. You know, you've been there and done that, right? And those employees just pop right back out of the organization. They don't feel connected. So in addition to all of this filling out the forms and all of that kind of stuff, have other things such as a welcome banner, balloons that everybody in their department gets together and has cookies with them on the first day, that the boss takes them out to lunch on the first day. Just little extra stuff that makes them feel really connected. So that's a whole different topic and presentation. All right, so what else? On page 3, you have to provide them, and this is new as of last year, so hopefully you got the information on this. You have to provide non-exempt employees a separate notice that says what their rate of pay is, regular pay days, name of employer, all that information that I have on there. It's only for non-exempt employees. You have to provide it to them upon hire, and it has to be separate from other information that you're giving them about their job, according to the Labor Commissioner. So hopefully everybody is doing that one. Right to workers' compensation, and so you've got to provide that little pamphlet. Now, most workers' comp carriers provide that to their employers. So hopefully the person that's doing your workers' comp is providing that pamphlet to you. But if they are not, then you can download it from a variety of sources. But the thing is on the workers' comp pamphlet, usually what they have on there is personal physician pre-designation and chiropractor pre-designation. So you are required, if you provide health benefits, to have this information. No, sorry, not health benefits. Everybody has to provide workers' comp. And if you are providing the information yourself, you have to provide a separate form that allows them to pre-designate their physician and their chiropractor if they get into an accident. And so what happens then? If they get into an accident, they go to their physician, they go to their chiropractor. So you've got to provide them with that information. Usually it's on the workers' comp pamphlet that your carrier gives you, but if it's not, you need to provide that yourself. Okay, all right. So here's some other workers' comp information that if somebody gets hurt, you've got to provide them with how to manage their injury. If they're a victim of crime at work, you've got to give them information on how to manage that situation. And the employer's first report of occupational injury or illness. This goes to your insurance carrier. So if you're doing any of the workers' comp kind of stuff, then that's information you need to know.
I have a doubt Somebody gets hurt and do they have to go to their provider first and then they go to their own physician, or?
No, no. If they have pre-designated their physician, they go to their physician. Yeah.
That physician has to accept that they'll take them, correct?
Yes, yes.
Because a lot of them don't want to deal with work.
Yeah, yeah, yeah. But yeah, so there's some forms that have to go out to the physician and they have to complete it and all of that kind of stuff. So it's a little bit more than just take me to Dr. So-and-so. But yes, that's the whole point of it, is that if they get injured, they go to their physician. Yeah. And the chiropractor thing sounds pretty funny. Yes, take me to my chiropractor so I can get adjusted, but, or acupuncturist. Yeah. But that's the deal. Yeah. All right. So OSHA, if you're handling any of the OSHA stuff, you're probably familiar with the fact that you've got some postings that you have to do at certain times. And so you've got the incident report that has to be posted. You've got the log of all of the incidents that you've had that has to be posted, and the summary of work-related injuries and illnesses has to be posted in a conspicuous place during specific time periods so that employees can see what injuries are being caused or happening at the job. Okay, so any questions about that stuff? Good, because I don't know that much about that
What
stuff.
about the IIP plan?
Oh, that's next. Yeah, so injury and illness prevention plan. Yeah, that's all right. So I say here it's required by law for most employers. Now, every employer is supposed to have some kind of plan that they communicate to their employees. But if you have fewer than 20 employees, it doesn't have to be written down. It can just be verbal. Now, I don't like just the verbal stuff, right? Because then how are you going to prove it, right? So I think every employer should have something written down. And the nice thing is that the IIPP, you can just go on to Cal OSHA. They've got a template. You just fill in a couple of spaces and boom, you've got it. So it's really easy to do. So Cal OSHA website, they've got the template. They've got different templates for different industries. So if you're in a high hazard industry, which none of you are, but for folks who are, the high hazard industries have their own version of it, and then the more office work and that kind of stuff has their own version of it also. But it's very easy to do, and it's easy to prove that you've got it.
And it needs to be updated every year, right?
I think it's a good idea to update it every year. I don't think you're required to. The only reason that you would need to update it is that if information changes, and one of the suggestions that they give in completing it is don't put people's names, put people's positions. So that way you don't have to update it all the time. Yeah, so if something happens, the office manager will handle, or go to the office manager, as opposed to go to Robin, because Robin's no longer there and now we have to update it. Yeah. Okay. Emergency action plan, same thing, is smaller employers are not required to have one written down, but again, I think it should be. Why not? It doesn't have to be that big of a deal. It just tells people where to go in case something happens, what the exit routes are, where we're all going to meet under the tree, you know, that kind of stuff. So it doesn't have to be that big of a deal, and it's readily available on Cal OSHA. Just fill in the blanks and print it up. Fire prevention plan, same thing. Okay. Hazard communication program, same thing. So that's the stuff on the safety stuff. And again, Cal OSHA's website is great if you haven't visited. It's very helpful. It's got lots of information, especially for smaller employers. All right, so next, state disability insurance pamphlet. You're required to give that to all new hires to let them know what happens if they become disabled, and if something happens, you've got to give it to them within a certain amount of days because of disability. They got hurt, they're pregnant, what have you. Paid family leave pamphlet. So I want to go over this a little bit because employers are really confused about paid family leave because it's a misnomer. There is no requirement for smaller employers to give people time off for family leave. not for their own medical situation, not for their kids, their spouses, anybody. So for smaller employers, they don't have to provide any kind of sick leave. They don't have to provide any kind of medical leave for their employees whatsoever, yet. All right, I'm sure that will be changing before too much longer, but yet they do not have to. And so when people see paid family leave, they think, oh, well, my employer has to give me time off work and they have to pay me too while I'm on family leave for doing whatever. It's a misnomer. What paid family leave is an insurance program, and it's much like disability, SDI. It's much like unemployment insurance, okay? So what happens is that our employer collects money. That's a nice way of saying it. Or you could say takes money out of our paycheck and gives it to the state. And if we become disabled, we collect disability. And if we become unemployed, we collect unemployment. And if we have to take time off work and our employer tells us we can because of a medical issue or a family's situation, then we've got this insurance. It's called paid family leave. It's just insurance, just like disability and just like unemployment. The employer doesn't provide anything except this pamphlet that tells people, if you're in this situation, contact the state, try to get your paid family leave. And so that's all it is. It doesn't give employees the right to time off work whatsoever. Okay? So that is a misunderstanding that lots of people have about that. But you've got to provide the pamphlet that tells people if you've got to be off work and we're giving you this time off work, you can get money while you're at home because we're not paying you to be off work. Okay? All right. Medical leave notice. So once you hit 50 employees, you got a whole bunch of other stuff that kicks into gear. So Family Medical Leave Act, or FMLA, and you've got to provide notices to people who need to take FMLA. Now, the qualifications to take FMLA are this. An employee has to have worked for the company for at least a year. It doesn't have to be consecutive, but at least a year prior to taking the time off work, and they have to have worked 1,250 hours during that year. So that's the qualification. And still, it doesn't mean they're automatically qualified to take time off. If they're a high-level position and 12 weeks off of work would be a detriment to the business, employers don't have to provide people with FMLA. So just because they qualify doesn't mean they automatically get it. Okay, so here's the trick. The employer has to be aware of what's going on when people are telling them things to know if they qualify for FMLA, because the employee is not required to come in and say, I need FMLA. They're not required to use any kind of specific language whatsoever. The employer is supposed to be smart enough to be able to go, oh, based upon what you're telling me, you are going to be under FMLA, and they have to provide them with all the information that tells them what FMLA is all about. You get 12 weeks off of work, you get to come back to your same job, you can apply for disability or for paid family leave during that time. The clock starts now, and then we're going to have some notifications that you need to provide for us to make sure that you're off and you qualify for it and that kind of stuff. So it's the employer's responsibility. Now here's this court case that happened recently. An employee, and this guy was managing the place, had taken a lot of time off work because of depression. And so he finally got to the point where he turned in a vacation schedule to his employer. And he said, I will be taking vacation for the following days due to my health situation. So he told his employer that's what he was doing. The employer emailed him back and said, yeah, I'm not granting this vacation time. You don't get it. And so the employee emailed back, I'm not asking you, I'm telling you. So the employer, and he said, I've got all this vacation, I could be taking a lot of time, but I need this time off work to deal with my health issue. And so the employer called him up and he said, hey, we've had a good run, but you're done. Bye. Fired him on the spot. So the employee went to the doctor with his FMLA forms, and he mailed them into the employer and said, I qualify for FMLA based upon my doctor's information. And the employer didn't answer him because he's fired. Why am I dealing with this medical certification stuff when you're gone? You don't even work here anymore. And so the employee, of course, sued the employer for denying him his FMLA rights, and he won over $1 million. Now, in the court, the employer said, but he didn't request FMLA. And the court said, yes, he did. He was telling you he had a serious health condition he needed time off work to deal with. He was even going to use his vacation time to do it. So he said, he put you on notice. You're just not bright enough to realize that's what was happening. Okay, so that's one of the things you got to make sure of. Employees don't have to come up and say, I need my FMLA leave and all of that. All they have to do is put you on some kind of notice they need time off work, and you're supposed to go, oh, FMLA. Okay, so that's the moral of that story. All right, so you have to provide employees information about their FMLA rights or CFRA, and we'll get to that in just a second. Pregnancy disability leave. So if you become aware that somebody is pregnant, you've got to let them know what their rights are. Now, the DFEH has a nice little pamphlet for that. Again, all you have to do is get on their website, print up this pamphlet, and give it to people. You're not required to provide them with the pamphlet. You are required to provide them with information. Pamphlet's the best way, right? The state's telling them what their rights are. Okay, so that's the way to go, I would say. So it says under other DFEH discrimination pamphlets, discrimination based upon disability, you're not required by law if somebody is disabled to provide them with this pamphlet. But if somebody becomes disabled on the job, it's a nice thing to do. Again, not required, but I think when you're providing people information about their rights and you are demonstrating that you are doing so, that helps you if you ever have to defend yourself against discrimination.
I have a question.
Yes.
If a pregnant woman is interviewed for a job and you don't hire her, would that affect you somehow?
It could, yeah. So for those who are streaming in, the question is if a pregnant woman applies for a job and you don't hire her, could that affect you? You certainly do not want to not hire her because she's pregnant. Okay, so the reason you're not hiring her is because she's not qualified for the job. You have a better applicant. You need an employee for a specific time period because it's a temp position and she's not going to be able to fulfill the requirements of that. Those are the reasons you would not hire a pregnant lady, not because she's pregnant, because that would be illegal. So if you do not hire her, you're certainly not going to tell her, I'm not hiring you because you're pregnant, okay? But you don't have to tell her that for her to go, the reason I didn't get this job is because I'm pregnant. Then she goes over to the Department of Fair Employment and Housing. She files a complaint with them. The DFEH comes to you and says, you've got a complaint that you have to answer, essentially proving why you did not hire her and that it had nothing to do with her pregnancy. And so that's why I say keep applications on file. When you interview people, keep the interview notes on file, keep all of that on file, because when the DFEH comes to you and says prove that you didn't discriminate against this person, you go, look at this application, it's not even filled out completely. Look at these interview notes, she didn't even answer most of the questions. That's why we didn't hire her. Yeah, if anybody has any inkling whatsoever that they've been discriminated against for whatever reason, they trot over to the DFEH and file a complaint. And then you've got to answer it. Now, you may have a legitimate reason for not hiring that person and you are able to prove it, but it costs time and money to go through that. So that's why your interviewing process needs to be really on the up and up, okay? All right, so where it says other DFEH discrimination pamphlets, it says California Family Rights Act. So I want to talk about that for a moment. Again, it's for not you yet, but when you hit 50, it's you. So CFRA, California Family Rights Act, and FMLA, Family Medical Leave Act, are essentially the same thing for the most part. It's just the federal government came out with their law, and then of course California came out with its own version of the law. It's a little different when it comes to pregnancy. And so this might be a little bit more information than you want to know, but you know, it's here, we have time, so why not? So FMLA says you get 12 weeks off of work to care for your own serious health condition, that of a parent, spouse, child, domestic partner, military service person, etc. California says essentially the same thing. How they differ is that FMLA includes pregnancy. California does not. In California, we have something called pregnancy disability leave. That is the same thing, according to them, according to FMLA. So if you have 50 or more employees and a woman goes out on pregnancy disability leave, she gets 4 months off of work while she's disabled by the pregnancy and the birth of her child, and then she gets to come back to her job, or the exact equivalent thereof, okay? So if you have 50 or more employees, while she's out on PDL, she's burning her FMLA, okay? And so, and what I mean by burning it, hopefully everybody knows, you're subtracting, okay? You're now down to 11 weeks, you're now down to 10 weeks, this is all you've got left, all right? So those run concurrently, FMLA and PDL run concurrently. Now here's the kicker in California. FMLA includes baby bonding, CFRA includes baby bonding also. While the woman is on PDL, she's burning FMLA. So she has the baby, and then if she qualifies, then she can take her CFRA for baby bonding. So she can be off for 4 months during PDL, and then take an additional 3 months under CFRA. So 7 months off altogether, if it's a large employer, and she qualifies for it. Okay, so that gets a little confusing sometimes, but that's where the California Family Rights Act comes in California. Okay, any questions about that stuff? Yeah, it's a little hard to wrap your head around when you're first learning this stuff, but it's important to know. All right, so if you provide health insurance, you have to provide information about COBRA, and here's one of the things that most employers don't know. You have to provide them with their COBRA rights when you hire them and when you terminate them, or they terminate themselves. Okay, so most employers only know that you give COBRA rights when they're walking out the door. No, you have to do it when you hire them also. So now, there's such a thing called CalCOBRA. Of course there is. So if you have 20 or more employees, it's COBRA. If you have fewer than 20 employees, but you provide health insurance, it's CalCOBRA. And so same thing, you have to provide employees with information on their way out the door, whether you're terminating them or they're terminating themselves, you have to provide them with this information. This is how to extend your health insurance coverage in between jobs. Okay? All right, most people have a COBRA administrator who does all the work for them. That's really a way to go. So you don't have to worry about all of the notifications, because there's lots of notifications. It's not only notification to the employee, it's notification to the employee's dependents and beneficiaries also. And if that dependent or beneficiary is living in another household, you've got to track them down and give them that notification. And so that's why a COBRA administrator is usually the best way to go, because they're responsible for making sure all those notifications get to everybody that they're supposed to. And again, if you don't provide the notification and something happens, you can get in trouble for that. All right, so report of employee to EDD. So as soon as you hire that person, you've got to let the Employment Development Department know you've got a new person on board. Easy, you can do it online. So not that big of a deal, but you've got to let them know. And if you have an independent contractor, you have to let the EDD know. I'm sure lots of employers are blowing it on this one. They hire an independent contractor to come in and do some work for them, and they don't think whatsoever that they have to report that to the EDD, and they do. All right, so acknowledgement of training is under that. It's not bolded because it's not required. And it's not required to provide any training whatsoever except for what? Safety training. You're required by law to provide safety training. So it's not a requirement to provide any kind of training, but training is good, right? Yes. And you want to acknowledge when people are doing the training. Keep track of that. Now, one of the reasons for that is to make sure that everybody gets the training that you want them to get. But the other reason for that would be that if you're providing training and employees are doing stupid stuff that they're not supposed to do, you've got that there to say, look, we provided you with the training. Why are you doing this stuff? Now we're going to have to write you up because we told you about it. So it's good to verify you're providing all of the information to people to be successful in their jobs. And when they're not your fault. Emergency procedures, and so again, written emergency procedures are required for employers with 10 or more employees. Why not just have them for everybody? They don't have to be extensive. You just have little notices that says this is the exits and this is where we're meeting and that kind of stuff. Benefits information. So if you provide benefits about how people could be, or if you provide benefits and people could be eligible for those benefits, not required by law to provide them with any kind of written documentation whatsoever, but still a good practice. And again, employee handbook, not required by law to provide an employee handbook. And there are some folks who say that you want to not provide an employee handbook because once it's in writing, you're stuck. They're exactly right. Yes, once it's in writing, you're stuck. So you want to make sure that employee handbook has things in it that you want to have in it and doesn't have things in it that you don't want. Now, lots of employers make the mistake of just downloading an employee handbook off the internet. And we have a client who did just that. And one of the things that he did was he printed a handbook for a large employer. And so it had stuff in there about FMLA, CFRA, had these extended medical leaves, which are not required to provide, had all of this stuff for a large employer. He only had 10 employees. But once you give it to folks, then you're stuck. And so he wasn't stuck on the FMLA and CFRA. I mean, that's only for employers with 50 or more employees. But he was stuck with the extended medical leaves that he was giving folks that he's not required by law to give. But once they're in that handbook, you are. So, yeah. So you want to make sure your handbook has the laws that apply to you based upon your size and the leaves that you're willing to give people if you are. I mean, bereavement leave, not required by law. So time off for all sorts of things that employees give, not required by law. But if it's in your handbook, you got to give it. Personnel files is something I get lots of requests about information about personnel files, what are supposed to be in them, what's not supposed to be in them, and so I thought I'd just stick it in here. All of these notices you want to put in the personnel file, right? So anything about hiring and orientation documents, and so that's your new hire checklist. That's all of the forms that you've had the employee complete, such as safety and things that you're giving them, keys, phones, that kind of stuff. You've got that stuff that they have signed, that they've accepted it, and that's it in their file. By the way, while I've said that, I just do want to add this little tangent here because we just had an employer who asked us about this. So they had the employee fill out a form that said, if I do not return the company phone to you, then you can deduct the payment out of my paycheck. And so they had that form, they had the employee sign that form. Okay, you can't do that. That's against the law. You can't require, if employees don't turn in equipment that they've been issued and that kind of thing, you can't deduct the cost of that equipment out of their final paycheck. And so those kind of forms you need to be really careful about. Again, a lot of people download those things or they had them from their previous company or whatever, and it doesn't matter whether the employee signed it or not. It's illegal. So be careful about that stuff. All right. Yes.
What about charging them for uniforms at the beginning of their employment
Mm-hmm.
and having them or reimbursing them back later?
For the most part, you cannot charge them for uniforms. If they are required to wear uniforms as part of their job, the employer has to provide it. All right, so performance documents. So hopefully people are doing performance reviews, not required to do performance reviews. I know some employers do not give performance reviews because they can't give people raises. That's a bad practice. Don't time your performance evaluation with a raise because people, it's like Pavlov's dogs. My performance evaluation, I'd like my money, please. You know, and so don't do that. If you give raises, give them separate from performance evaluations. So that's one of the best practices. But the other thing is that some employers say, well, we're not giving raises, so we're not doing performance evaluations. That's a bad practice to get into. You want to review people's performance at least on an annual basis. Why? Because if their performance is poor, you want them to know. If their performance is good, you want them to know. But especially if it's poor. Because if they have no idea that their performance is poor, you've never told them until you finally got so fed up you wanted to fire them. And then they come and they sue you for discrimination because you fired them because they're a woman who's over 40. And you say, no, I fired them for poor performance. And the DFEH says, where's your documentation to demonstrate they were a poor performer? I don't have any, but I told them a bunch of times, no good. Yeah, so that's why performance evaluations, truthful performance evaluations, this is one of the places where people lie about things. And I just had a lunch and learn, I think last month, about keeping it real in HR, being honest. And performance evaluations is one of the places people are not honest. They lie to them because they don't want to hurt their feelings. They don't want to have a hard conversation with people. So they rate them satisfactory when they're really not. And then they've got this performance evaluation that says they're satisfactory, and then they fire the person for being unsatisfactory, and then they have to turn over that documentation to the court that's used as evidence against them.
It could be the other way around too.
As far as good...
You do an evaluation and they're doing okay, but you show that they're not.
Well, yeah, and I don't see employers getting in trouble for that. It's more the other way around. Google is facing a lawsuit right now where this happened, where they had an employee for a year and a half. They gave him one performance evaluation during the year and a half, okay? It said he met or exceeded all expectations, and then they fired him, they said, for poor performance. And he said, no, I don't think so. I think it's because I'm a 54-year-old man and everybody else running around here is 25 years old. They're all telling me I'm the old man. They're playing jokes on me. They have nicknames for me. And so they fired me because I'm the old guy. And that one's in court right now. All right, so the one documentation they had, well, they also gave him bonuses. So he's got his pay stubs for the bonuses based upon performance. But that performance evaluation is exhibit number 1 in the court case. So that's why you got to be truthful on that stuff if you're going to do it. All right, where are we? Do not include in personnel files harassment complaints. Any ideas why not? Somebody is complaining about harassment, you write up the complaint, you put it in their personnel file, and then they want to move to another department, and you give that personnel file to the hiring supervisor there who looks at it and goes, oh, they're making complaints? I don't want a complainer on my staff. And so you don't let the switch happen as a result of that. So essentially you're punishing somebody for making complaints. It happens, and it's not supposed to happen. And so that's why you have to protect that information. So if somebody's making complaints about anyone, you don't put that in their personnel file. Now, the person that the complaint is about, if you do an investigation and you determine, yes, the complaint is valid and we took disciplinary action against this person, you put that in their personnel file. But the person who made the complaint, you don't put that in their personnel file. All right, medical information has to be kept separate. Separate files should be in a separate location also. Same kind of reasoning. You've got somebody who wants a promotion, look at their personnel file, see, oh man, they've got all sorts of illnesses. We don't want to promote this person. And so you use that information against them. Not supposed to, but it happens. So that's why the medical information has to be separate, so it can't be used against people in employment decisions. EEO classification information. And so all of that information that you're collecting from your employees about their race and their sex, you're keeping that in a separate file all by itself. That's not in their personnel file. Why? Same reasoning. Somebody looks at that and doesn't know the person who wants to apply for a position in their department, and they go, oh, this is a woman over 40. I don't want a woman over 40. I want somebody young. So that's why you have to keep the information separate. And then I-9 forms. Now, here's the deal. It used to be that you had to keep I-9 forms out of the personnel file, that you had to keep them in a separate file all by themselves. That's no longer a requirement, but it's a good practice. And the reason it's a good practice is this. If immigration control folks come in and they want to look at your I-9s, you don't want them going through all the personnel files. You want to just be able to hand them a file that just has your I-9s in it. And so that's why it's a good practice to keep it separate. Once they start going through those personnel files, anything they find in there, they can use against you. Okay, so that's why you want to limit them. All right, so where should personnel files be kept? Under lock and key, definitely. And limit that key to one person or one department, certainly. But lots of people keep information out on desks and all over places, and that can get you into trouble if you don't. So you got to be really serious about that. Mm-hmm.
What about digitally, web-based?
You can keep it digitally, yes. So it's perfectly fine to keep all of these files, but you need to limit the access to people in a certain department or just one person also. Yeah, so that's very important that you've got to build whatever barriers so that other people can't access it. Okay? So employee has the right to inspect their file and must be allowed to make copies of documents that he or she has signed. So there was a law that, or an amendment that was passed this last year that allows employees much more access than before. And so one of the things that employers often do is they say that you can only look at it once a year or something like that, and that's not true. It can be in regular periods, reasonable periods. And so the thing is that you can control it to a certain extent. If an employee wants to look at their personnel file, you can make them make an appointment. You can take things out of the personnel file that you don't want them to see, such as your conversations with their previous employers that you recorded and is stapled to whatever you've got in there. You can sit there with them while they are looking through their personnel file. And then make copies of anything they want copies of that they have signed. Okay? So how should files be kept? Or how long should files be kept was what that should say. And there's one of the things about records retention. It gets a little messy because there are different requirements for different things. So there are laws about how long you have to retain certain information. And so one of the things, the best practice is just keep everything for at least 10 years after the employment has terminated. And then when you go to destroy it, you can't just throw it out in the trash. You've got to hire somebody who shreds for a living. You have to verify that their shredding practices are on the up and up. Or you can burn it all, but then you might get in trouble with our air control people. So you need to be careful about that. All right, discipline. So you need to keep investigation documentation. And so here's one of the things. You are required to do investigations if somebody complains about something, and especially if they're complaining about harassment or discrimination. You are required by law to do an investigation. You want to keep all that documentation on hand in a separate file. So again, you can defend your document or your investigation practices. Just heard a great presentation at our local Human Resources Society function. I don't know if you're familiar with SHRM. Are you familiar with SHRM at all? Okay, it might be something that you want to. Monthly meetings. We had a great presentation on investigations. Actually, all of you might want to be involved in that. But anyway, the investigation was talking, or the presenter was talking about the fact that when you do an investigation, you don't have to prove that someone actually did what they're accused of doing in order to fire them. If you think they did it and your investigation was in good faith and done thoroughly and fairly, then if they come back and say, I didn't do what you accused me of doing, even though you fired me of doing it, courts were more likely going to rule in your favor if they can look through that investigation report and go, no, it was fair, it was unbiased, it was thorough, it was done professionally, and they thought, based upon the investigation, you did it, and that's why you got fired. So good enough. So that's good news. All right. After the employment relationship, speaking of firing people, you have to give people their final paycheck if you fire them when you fire them. And I just had an employer had to go around, he goes, well, we have automatic or direct deposit. Can it just go to the direct deposit? No. When you fire that person, you have to hand them their final paycheck. And so failure to do so can get you in trouble. And people go, but I want to fire them right now and I can't get that final paycheck. Wait to fire them until you give them the paycheck. So in this one particular client inquiry, I said, just tell the person not to come to work until 10 o'clock that day when you can have that paycheck for them. Problem solved. So that's one of the things. If the employee quits, you can give it to them within 72 hours. Final paycheck acknowledgement form is not a requirement, it's a best practice. Have a form that says, here is how much your final paycheck is. This is what you're getting for vacation or PTO. These are the deductions that have been made as a result of these things. Here's the total, sign here that you received it. That's a nice thing to have, because if they come back and they say, I didn't receive my final paycheck, you say, yeah, you did. Here's the documentation. EDD notice. So here's one of the galling things that employers have to do, is that if an employee quits, you have to give them information on how they can collect unemployment. No, sorry. If you fire them, you have to give them information. Well, either way, you have to give them information. But the galling thing is that when you fire somebody for poor performance or because they set your building on fire or whatever, you have to give them information on how to collect unemployment. Even when you fire them. Yes. Now, if they quit, you have to give them that information too.
I say, and then you have to fight.
Oh, and then you have to fight the unemployment. Yeah, yeah. So, I mean, that's one of the things that is just, employers are just baffled when I tell them that. I'm firing you, here's how to apply for unemployment. Good luck. See you at the unemployment court. All right, written notice of change in employment status. You have to provide this form also. Most employers are unaware of this and they don't do it. They think that the final paycheck is all they have to provide. You have to provide a notice that says our relationship is changing because you're being terminated on this day. And then you sign it, they sign it, and they take it to EDD. All right, now, one of the things that you can do on there is when you say they're being terminated, you can put the reasons they're being terminated. And a lot of employment attorneys say, don't put the reasons because that's going to get you in trouble. They can fight it. And our advice is do put the reasons. You want to attach a separate piece of paper listing all the reasons if you want to that says these are the reasons this person is being fired. Failure to show up to work on time. On and on and on and on. And so when they go to apply for unemployment and the EDD looks at that and they go, oh, well, we don't want to give you unemployment. Okay, so that's a really good reason to have all of those things listed because you don't have to go through the process of fighting it. They do it beforehand.
Even if the person who's being fired doesn't want to sign that document.
Doesn't matter. They don't have to. You just put refuse to sign. So yeah, and that's one of the things somebody told me the other day, the EDD does not accept anything like verbal warnings or written warnings or that kind of thing without the employee's signature. They don't count if the employee has not signed it. Have them do it anyway and give it to them anyway and have your copy on file anyway. Yeah. So, and one of the things do not do, and this is where the lying stuff comes in also, one of the things that people do sometimes when they're firing somebody, they're telling them they're being laid off, but they're really being fired. Don't do that. If they're being fired, tell them they're fired and this is the reasons you're being fired. Why? Because if they file for unemployment and you fight it, and EDD says, why did you get rid of them? We terminated them, but you said that it was being laid off. Well, we really terminated them for cause. Well, were you lying then or are you lying now? So don't do that. Okay, you can't protect yourself when you lie. HIP notice. Most employers are unaware of the fact that you have to give somebody a HIP notice. This is not HIPAA, this is HIP. This is a special notice that says that the state can provide insurance, medical insurance, while the person is unemployed. So you have to provide that, as well as HIPAA. Again, if you provided health insurance coverage, you have to provide them with information. Now HIPAA, most people are familiar with the fact that HIPAA protects the privacy of your medical information. Well, that was not the first part of the law. There are two parts. All right, the first part of the law is that you can't be discriminated against because of your medical information. And so HIPAA says that employers can't refuse to give you health coverage because of your medical information. That's what HIPAA originally is. And then the second part of it was that it protects your medical information. So you have to give employees certification and that kind of thing if they ask for it that says that they can have their health coverage continued. COBRA forms we've talked about. Look at all the stuff you have to provide. That's why I said get a COBRA administrator. CalCOBRA we've talked about. Not as much notification. You can usually handle CalCOBRA by yourself. It's usually not that big of a deal. ERISA, if you do provide 401k, retirement, anything like that, you have to give the terminating employee information about their benefits at that point. Usually the benefits provider is providing that information, but you just got to make sure it happens as well. And then warn notice. So this is larger employers also. So the federal version of it is 100 employees. If you've got 100 employees and you're going to close down the plant or you're going to lay off a whole bunch of people, you have to let them know in advance. This is what's going to happen. 30 days in advance, you have to say, we're closing the place down or we're laying off all of these jobs or what have you. California, of course, has its own version, and the threshold is 75 employees. So you get to 75 employees, massive layoff, plant closing, got to let them know 30 days in advance. Okay, so any other questions at this point? Any questions about other things that aren't part of the forms and notices and stuff? No? You're good to go? All right, well, that's a lot of information, and that's one of the reasons we printed it all up in this little thing, so you can keep this on hand. You can come back to it. It can be your guide. This happened, now what do I need to do, etc. The nice thing is there are so many government websites at this point that provide you with the pamphlets and the notices and that kind of thing for free. The Cal Chamber poster I told you about is not for free, but most everything else, if it's provided by the government, has to be for free. And you get to just download that and send it on to the employee. So good luck in your effort to let employees know what their rights are. Once again, it is the employer's responsibility to make sure the employees know what their rights are, and in some cases, to navigate those rights for them. And so good luck in that effort. And thanks for coming.
Thank you, Robert. Now we know.
And your life is better for it.